So, good evening, everybody. My name is Luke Piper. I'm a solicitor at the Work Rate Centre. We're a charity that provides advice and support to people we're here working in UK, and we've developed a particular focus on providing advice and support to people who are here under the health and social care visa, which is the subject that we'll be talking about today, looking at immigration and employment issues and how all these things interact with one another. And here's a brief structure of what we're going to be looking at. I'm just going to cover some of the basics that people will be familiar with about the health and social care visa, the basics, the conditions, and what basic rights you have that are associated with that visa, because I think there's a lot of misunderstanding about that, particularly from the people that I speak to. And then thinking about alternatives, thinking about finding new sponsors, and talking through case studies, how all these things interact with one another. And we'll have plenty of time for discussion at the end. The recording I intend to end at the point of discussion so that people who are here on the call today can feel free that they can talk about their issues, and we can talk through the legal points. So, from the outset, health and social care visas, for most people who would be familiar with this, is just briefly looking at what it means to get one, to come and live in the UK with a health and social care visa. Its basic requirements are that you would need a certificate of sponsorship from the employer, licensed by the Home Office. You need to pass an English language test to the appropriate level, have sufficient funds for yourself and your family, or have your maintenance, as it's called, certified by the Home Office, and have some particular documents such as criminal record checks. And most people who'll be interested in this session today will be familiar with these requirements. But the reason why I'm bringing them to everybody's attention at the front of this is because there's some significance in terms of how all of this interacts with your rights and your expectations from working here in the UK. So, one of those really important things that was on that list there is salary and how it's reflected on the certificate of sponsorship. And overwhelmingly, the majority of people we're thinking about today are those who are sponsored into care worker and senior care worker roles. And there were some transitional arrangements that happened earlier this year that meant that people now moving into this route, these are the minimum salary requirements that are expected. And when I say salary, I mean salary. I don't mean hourly rates. I don't mean you get paid for the time that you put in. I mean your salary. And I'm going to talk a bit more about that because that's another common issue that people have talked to us about. So those who have been given certificates of sponsorship before 4th of April, if they're moving to new sponsors, they need to be paid at least £23,200. But anybody who's entering the new route for the first time, the minimum amount is £30,960. Now, the process to obtaining is again, would be something that's quite familiar to everybody. Here is filling in an online application form and paying Home Office fees with the online application. You don't need somebody to help you to fill in the form. It's something you can do yourself, but sometimes it's good to have a lawyer to help you if you need to. Crucially, and this is a really important part of the process, is that you don't pay an immigration health surcharge, just the visa fee. And what's also particularly important in this is that the employee should not be charged for any other costs. That includes recruitment fees, skills charge, the certificate of sponsorship, or even the license fee. This is a common issue that we've seen, is that people have been told that they have to pay this stuff. You don't. If your employer wants you to work for them, you shouldn't be having to pay recruitment fees, and you shouldn't be having to pay the immigration skills charge. You should just be paying your visa fee to come and work in the UK. I'm going to talk a bit more about this issue in the future, because I appreciate that for a lot of folk, they will have paid agents a very large amount of money to come here when they shouldn't have done. And particularly, this is about thinking about going forward. It's a big red flag. If you're looking for a new sponsor, looking for somewhere else to work, if they are asking you to pay recruitment fees or covering any of the visa costs other than the visa fee itself, which you should be paying, that's a big red flag that this is a business that is probably not going to really look after you and respect you. Thinking about dependents, family members who can join under the root. Again, this is a common issue that gets brought up, and I'm just covering the basics here, which we're going to unpack a bit more further on in the presentation. But just so we're all very clear about which family members qualify for those who are care workers and senior care workers, is we're looking at people who came before the 11th of March 2024 and continue to be here as a health and social care visa. They can bring their spouses, partners, and dependent children. Anybody who enters the route after the 11th of March can no longer bring dependents with them. So that also includes those who are inside the UK wishing to switch into the health to care worker and senior care worker roles. There's some circumstances that we've come across where one partner may be working in the UK and has a health and social care visa, and they, for whatever reason, are unable to work, and then the sponsored dependent then wants to switch and become the main skilled worker, become the skilled worker, the sponsored worker. And there's a risk with doing that, because if they want to switch into being in that role as a care worker, a senior care worker, then the family wouldn't be able to apply as dependents. You've got to be really careful about this particular requirement. If you've got your family here and you're looking to move sponsors, you're looking to move into a different employer from the situation you're in, or somebody's wanting to come to the UK. Now, thinking about rights associated with this visa, and this is the key thing that I want to talk about today, and we're going to unpack this a bit more as we go further on in the discussion. So, rights under the health and social care visa. So everybody who has a status under this route has what's called leave to remain. It's a limited form of leave in the UK, usually up to 5 years and sometimes a little bit less. And the fundamental condition of that leave is that you're working for the sponsored employer, and you can work for them full time. And whilst you're working for them, you can also do some supplementary work of up to 20 hours a week for other employers in specific categories of jobs, as long as you continue to be employed by the sponsor. This is a really important requirement, one that often gets overlooked and can cause some potential problems. But looking back at when it says working for the sponsor full time, you must be paid what you were promised in line with your certificate of sponsorship. This is a really significant issue, and one that I know people have been reporting about a lot. But it's really important that you understand that it's what is said on the certificate that you should be paid. That's what the Home Office expects to happen. And if it says you're going to be paid a salary, then you should be paid a salary. Likewise, when you're looking at hours of work and things like that, there is some flexibility within that. But again, it's what it says in your certificate of sponsorship. That's the key document that sets out what you should be doing in accordance with the terms of your visa. Now, if there's any change in your full-time work, i.e. you're moving to a new employer, looking for somewhere else to go, then you need to get permission from the Home Office to do that. And that's the reason why I'm setting out what the rules are just there, to make it clear that when those changes happen, it's a new visa application. It's something you still have to do. The other restriction is you have no recourse to public funds, and that means you can't access public funds. There are some funds you can access, but they're very specific circumstances and usually in emergencies. And typically that's where people are really in trouble. You should seek advice if you're not sure about what public funds you're entitled to, if you really need that help. But importantly, dependents, spouses, partners, don't have the restriction on who they can work for. They can work for whoever. And a lot of people we've been speaking to have had to take full advantage of that. And in addition to these restrictions on your leave, are that you have the same rights as all other employees when it comes to working conditions and working practices. And this is something that can be quite complicated and a bit confusing, particularly if you're new to the UK. I'm not an employment lawyer, for example, I'm an immigration lawyer. But even for me, a lawyer, it can be a bit daunting sometimes not knowing the full ins and outs of what rights you have and what you can expect in terms of things that you can access and are entitled to. So I'm going to talk some basics about what you can expect, and you'll see that from when we're looking at the requirements of the route, you're looking at the rights, the things that you're entitled to. There's some things here that mean these are things that you are entitled to and you have rights to. We're going to talk briefly about what that looks like in terms of enforcing those things and thinking about negotiating those things, but also thinking about when you're looking for a new sponsor or a new employer, what you should be expecting and what you should be considering. So an overview of employee employment rights. So there's a massive list, and my intention is to share these slides at the end of today so that they can be provided to people and people can have a look and see the materials that are linked to. But there is a massive range of rights you can have on day one, and we're going to touch briefly on those, and some that you have to spend a bit more time in the UK, with your employer to be able to qualify for them. But crucially, in a lot of instances where these rights are being breached, you can bring claims against the employer for compensation for financial loss. But they're enforceable rights, which means that they are things that you can negotiate with your employer about. They're things you can speak to them about and say, look, we've got an agreement here, we've got a contract, or this is what I understand that I'm entitled to and I should be expecting, and something you should seek to enforce and should have a conversation with them about. Not everything essentially comes down to litigation in these things. Sometimes it's just about having a conversation. Can be uncomfortable, can be difficult, but sometimes that's what it comes down to, is to discuss and talk through the issues. That may not always be possible for some people, but for others it is. So some of these rights that we're talking about activate on the first day you start, and particularly relevant that we see in these sorts of cases are things like protection from unlawful deduction of wages. Now, I've seen a number of clients where they're on their pay slips that they've had deductions taken from them that weren't included in the terms of the contract. That shouldn't happen. There are some specific deductions that definitely must happen, like national insurance and tax, but there are particular deductions that shouldn't happen unless they've been negotiated. Likewise, you have protections from discrimination. If you're somebody who is pregnant, or if you have a disability, you can expect on day one not to be discriminated against because of your protected characteristics. That includes race and other categories. Also, you have what are called whistleblowing protections. This is where you have a legitimate concern about the way that the business has been done. It's maybe breaking the law, such as breaking immigration rules, like not complying with the sponsor's obligations, things like that. And you're notifying the employer, and you might want to notify the authorities about it. You've got protections from that, and these protections come with enforceable remedies to be paid and things like that. If you're genuinely trying to protect your position and that of your colleagues at work, you have specific rights. I should say at this juncture, it's really important to seek advice if you're in a situation where you're experiencing these sorts of problems. I'm going to talk about the kinds of places that you can go to get rights in the latter part of this slide, but I want to make it clear that these sorts of decisions about communicating with your employer should always be taken into consideration as part of a conversation with a lawyer or an experienced HR employment person so that they can talk you through your options and the risks and so forth. But it's really important that as a foundation that you have an understanding and appreciation that there are some rights that you have, and these rights offer you certain levels of protection. Some other rights to consider are that there are those rights that activate after a period of time, such as maternity pay and what's called unfair dismissal. So this is where somebody's dismissed unfairly. This only activates after 2 years. And this is particularly pertinent because we've seen, particularly amongst people we've spoken to, that there are instances where people have been dismissed because of unfair practice. And unfortunately, that only activates after 2 years. But nevertheless, it's always important to seek advice on these things because it may be that what you're experiencing falls within the framework of something else. You also have contract rights. What's written in the contract between you and your employer is a really important document. Like a certificate of sponsorship is a really key document in the skilled worker setting because it sets out basically a contract. Your terms of employment are, what the hours are that you work, etc. But most people also get another contract, and I'm going to talk a bit more about contracts in a moment. But it's really important to recognize that those also form part of an enforceable framework that you can use as leverage to negotiate with employers if you're in a tight spot. So it's important to consider rights in the link above that I set out. And if you have any doubts, you should always seek advice. There's 3 independent advisors out there. There is ECAS, there's Citizens Advice, there's specialist organizations that support certain rights like whistleblowing. And there's obviously us as well. We are a small charity, but we do have some capacity to give advice on employment issues. I should say by this link as well, I found that there are some helpful links as well to other organizations with specialists in different areas of rights and issues. So that's always good to have access to. My slides seem to have decided to stop working, so I'm just going to reopen that. Okay, right. So this is one of the key things that we get people talking to us about a lot, which is change of circumstances, finding a new sponsor, because sometimes it gets to the stage where there's no going back and the employer isn't actually legitimate, or they are somebody that has lied to you and you need to move away. What do you need to do? Well, you need to get a new sponsor. You need to put a new application into the Home Office to change jobs and change sponsors. There is an obligation to notify the Home Office of the change in circumstances, and that can form part of your application with the Home Office. But there is a general requirement to notify the Home Office when there's been a change in your circumstances, and that is when you are no longer working for the employer. In these situations, it's always good to seek immigration advice to understand what it is that you need to do. Now, when a lot of people that we speak to, they are often on the end of when the employer's license has been revoked. And they are in that desperate situation where they can't get work, and then they're needing to find a new sponsor, new employer. So what we know is that the Home Office has started sending letters to people impacted by revocation. I've had some clients who've received letters from the Home Office directly saying your employer's license has been revoked. You need to find somewhere else to work, and they give some resources. So maybe some of you will be getting those, others may not. We're going to talk about the kind of resources that are within that pack, but it's definitely something that's a growing feature. We expect to see the Home Office to provide more localized support to people in regions as this package widens and these letters go out more. It's also common policy, it's his policy that the Home Office curtails people's leave to 60 days when they are no longer being sponsored by their employers. However, there does seem to be a trend at the moment that there are big delays in curtailments and cancellations for people after their employers' licenses have been revoked. It's a bit confusing. It's a bit unclear what's going on, but we are seeing that there's been significant delays in cancellations on curtailments of people's leave. I have seen people's status being curtailed when they're in this situation, but in balance, I've seen fewer than the other side, where lots of people are just waiting. And it's not a great spot to be in because you can't work, but it does mean that when you find that new sponsor, you can move on. So finding an alternative sponsor. I don't want to distract that this is not an easy thing to do. I'm not saying it's easy. I know it's difficult. I've spoken to so many people in this situation, and I don't want to distract from how tough it is. That being said, it's not impossible. There are jobs out there, and I've supported clients with visa applications, and getting on with the process to switching to new sponsors. And some have been successful, which is great, but there are opportunities out there. Um, Things to keep in mind are that the certificates are a key part of the applications we've been talking about. I know that there's been delays in issuing certificates, but it's really, really important to have that conversation with your prospective employer, and apply before your leave expires. Now, we've put a bunch of resources together to support people with finding new sponsors. I am not a recruiter. I don't know the first thing about recruitment in this space, but we have worked with journalists and other organizations who do know a little bit more about this than I do. And there are some resources on our website, and there are some resources at the Care Visa Sponsor database, which you can find at that web address, workrightcentre.org/care-workers. And there's some instructions there, some tips there. We also understand the government's been working with local organisations to give support in their local areas. They've reallocated some funding to adult social services teams in the local areas. I would recommend, if you're in this situation, contacting adult social services, and saying you're wanting to speak to somebody about recruitment. Find out who the people are who work in these recruitment teams, speak to them, understand what packages are out there. I've managed to find 3 organisations that seem to be part of this shift in funding: East Midlands, South East, parts of London, some addresses there. I don't know for certain that they are providing support, but I've been told that these form part of the landscape of support and services that are out there. Again, just for confirmation, these slides will be shared, but if you're watching this on YouTube, then you can write these addresses down and then Google them. But my understanding is that there is help out there, and for some folk this has been helpful, for others less so, but more help is coming, is my understanding. But the key thing is finding that employer, getting that certificate, and applying before your leave expires. So thinking about other resources, seem to be repeating myself there, apologies for that, but there we are. So common issues and tips. So what are the common problems that we are seeing? I've sort of alluded to a lot of these in my presentation so far. And the big one is not sticking to what was agreed, being told that you got a job, everything will be great, coming here, and it's not the reality. Non-provision of work, no work at all or very little, agency fees, 0-hour contracts, unreasonable working conditions. We've had clients who've been overworked. I've spoken to some people who have been told to essentially do shift work across entire county using public transport. Completely unreasonable, unworkable. Deductions, harassment, bullying in the workplace, disability and maternity issues, and all of these things. There are tools to push back with. contract terms, things like that. And sometimes a lot of this is about negotiating your way through the issue. I appreciate that it's not always going to be the case, but given how precious these licenses, these visas are, and how the challenges of finding new sponsors, sometimes it's just working through these problems with your employer. And other times I appreciate it is about very much moving on. But tips to consider to prepare for employment law advice. And this is really important. This is sort of a universal thing when thinking about this stuff, particularly if you're going to be seeking advice about enforcing your rights so that you're in a stronger position, or thinking about looking at prospective employers going forwards. So document everything is probably the simplest thing to come out of that. But a key element of this is your contract of employment. You're entitled to one, and that should set out the terms of your employment, including salary hours. Think for certificate of sponsorship as also, because that's a really key part of this. All communications, including text messages and other, make clear your conditions at work, lack of work. Record everything. Don't just do it over the phone. Do it in writing. Confirm, back up things in writing. If you're speaking to somebody at work and you're having that conversation, follow it up in writing, in a letter, in an email, something that you can have a clear record of. Chase them for updates, record, document. So this is you building that evidence base so that should the worst come, you're in that strength of position to be able to have that conversation with a lawyer confidently and have that evidence so that they can advise you on the merits of any action that you can bring. So, scenarios. So there are some scenarios that I'm going to talk through and sort of helps get the thought process going. And then what I thought we'd do after that is go to discussions. I've left quite a lot of time to allow for conversations because I feel that that's really where there's a lot of value in this. And that's when we will be stopping the recording. But let's go through these scenarios so that we can unpick and apply some of the points that I've raised in the presentation so far. So, scenario one. I put these two together, and I should say this may be familiar because they are from the Power website, which I found helpful to see the examples of issues that people have been reporting. So first one, they paid £5,000 to a recruiter, and when they got the visa came to UK, they were just started to be ignored. So first thing to say is that agency fees are not allowed in principle. It's not something that should be happening. People shouldn't be paying unreasonable agency fees to come and work in the UK. And the problem is, after the event, it's really difficult enforcing recovery of that money. If you are able to, if there's a contract, if there's a paperwork that sets out the terms of the agreement, there's the possibility of a potential contract claim there. But you should definitely speak to somebody, get some advice on that, ACAS or Citizens Advice or some other organization that can give you advice on the recovery. Problem is that a lot of times that these agencies, these organizations, their jurisdiction is outside the UK, and enforcing things in another jurisdiction, another legal place, is really difficult. So really, when you're thinking about these things and trying to recover any kind of money, I can only speak to the UK law, but it would be in a UK setting. It's not always easy to get money back when it's been paid, but there are ways of doing it, particularly if it's with recruiters. If it's the employer who has taken the money, there is some scope there to integrate that as part of an employment claim, is my understanding. But again, that's something you should seek advice about. So the second part of this discussion here is when they came to the UK that there was no work and they just were ignored. Again, this is a common issue. And speaking with my employment colleagues in the team about this, one of the key things to be thinking about in this situation is whether there is an enforceable contract here, if it's an employment relationship. And it's something to be thinking about and speaking to employment specialists, lawyers about, as to whether or not there is something that can be enforced here in terms of recovering money whilst you are trying to find a new sponsor, which loops back to the point that we were talking about earlier. That it's really important to get that ball rolling and put in the work to find those new sponsors to be able to move to a new place of work and start fresh and getting away from whatever the situation is here. It's and coming back to also thinking about children. This person came with their 3-year-old. If they are then able to find a new sponsor, they can then move to that sponsor with their child. In the other story that we've got here is similar. Another person paid a sizable amount of money, but in this case, they're not getting the hours, and they're not getting the work that was promised. And they're not able to survive on that money. And again, that's not on in terms of a contract. Look to the contract, speak to somebody, get some advice about what can be done in terms of enforcing your rights to get further hours. We've supported clients in similar situations with fewer hours where they've turned around, spoken to their employers, had a frank conversation with things about this, and things have improved. But it's really problematic because at the end of the day, what was promised in the certificate of sponsorship is the thing that should be delivered in these instances. Sometimes, again, it's just not easy to be in that situation and you need to move on and find somewhere else to work. And a big part of that is coming back to what we were talking about before about finding alternative sponsors and being able to move on. It's also important to think about in this context the whistleblowing elements of these things, that this doesn't sound right in terms of compliance with immigration laws and employment laws. And it's something that you should speak to an employment lawyer about. The employment team, when I spoke to them about these scenarios, said that these people, in fact, should seek to understand whether or not there are any options to them to exercising any of their rights in that setting, particularly given that they're trying to enforce the contract and enforce other elements of their rights. Okay, second scenario. There's only 4, so yes. So this is somebody who is undertaking domiciliary care, and they, since joining the company, have never been paid their basic salary. Pay slips are not transparent. Paydays are not regular. Mileage and transport not paid as well. Refusing to give work referencing and other pointers here in this scenario. So there's a lot going on in there. Speaking to the employment team, there's a lot that's wrong, particularly around the deductions and things like that. Again, it's understanding your contract, it's talking it through with an advisor, understanding what can be enforced and exercising your powers to do so. I should say at this juncture, I think there's a lot of fear around employers threatening to report to the Home Office and things like that. Employers, if they're reaching for those levers as a means of threat, they are exposing themselves just as much as they would be exposing you. And I think if you're experiencing those sorts of threats, you should absolutely get specialist employment law advice so that they can advise you about the circumstances you're in and the exposure, both the employer and you. Because it's never just one-sided when it comes to the Home Office. If they're going around reporting their people to the Home Office, you can bet the Home Office are going to be watching them, particularly in the health and social care space. Lots of Home Office, hence why most of you are watching this or are here today. It's all because the Home Office is doing a big clampdown on scrupulous care providers and bad employers. So in this scenario here, there's a lot of ground here for seeking some advice to see if there are things that can be done to enforce the situation that they are in. I'm not an employment lawyer, but I know that pay slips need to be transparent and straightforward. I also know that you shouldn't be taking deductions. So it's really important that you get that advice, understand that there's a real range of rights that are being breached here. And again, thinking about what are my alternatives? What are my options? Thinking about the resource, looking to new sponsors, exploring those avenues, and having those conversations. Okay. Scenario number 3. My employer asked me again today to go for a 45-minute shift, but barely covers transport costs of getting there. Yeah, I've seen this before. And again, speaking with the employment team, there is potential, depending on how long this person was employed, potential unfair terms here, but crucially, this all folds into some potentially breach of contract areas, particularly if they're a sponsored worker. This speaks to me that this is not somebody who's not getting what was promised in terms of contracted work and in terms of the hours that they're putting in and things like that. So going back to their contract, looking at those terms and thinking it through with somebody who can give them some advice. But crucially, there is something that can be enforced here, not least because if you're a sponsored worker, this is not an acceptable arrangement. Scenario 4. I came here in March without knowing that I was pregnant. When I found out I was doing the right thing, when I found out I thought I was doing the right thing to tell my employer, they dismissed me. So, again, speaking to the employment team, pregnancy discrimination dismissal is wrong. You can take immediate action, have 3 months minus 1 day for those who've been dismissed. For those still working, the clock hasn't stopped. You should take action as soon as possible. Gather evidence communication. Points back to what I was saying earlier about building that evidence base. Understand what happened, get it in writing, get it explained. Equally, there's a potential whistleblowing element to this. Seeking advice around that is really important, but you shouldn't be sacked because you're pregnant. It's wrong. And it's something that you can definitely seek advice about and get some employment advice about what protections you have. As how that interacts with immigration, I would also be keen for this person to get advice because there may be some protections that can be put in place whilst this person is going through the pregnancy. It's really difficult to find work when you're pregnant, and because employers are very nervous about it. And it's about thinking about options in terms of whether there are any other types of discretionary applications that could be made to the Home Office in the event of a curtailment or a cancellation. I should say this is not exactly a very well developed area of law. It's not particularly clear. There's no obvious route to apply for status. Nevertheless, I would be inclined to have a conversation about what potential discretionary applications there are, how we notify the Home Office, what it is that we do in that discussion, and just talk through what people are comfortable with and what their options are and how they're presented going forward. Scenario 5. I work in domiciliary care and have been with the company for 6 months. Monday, my car broke down in the middle of calls. They gave me 48 hours to make sure my car is working or my visa sponsorship is terminated for failing to meet contractual hours. So generally speaking, when sacking up to 2 years, they can sack you if it's unfair. Unless you can show automatically unfair reasons, then you have to wait 2 years. So it may be, again, that there's some whistleblowing elements to this. It's something that you're reporting to them. You're saying that this isn't fair, it isn't right. But again, it's something you need to seek advice about. Joining a trade union, such as power and things like that, is also about understanding your statutory rights to asserting. And looking to the contract, where what was agreed, what were the terms that were agreed. As I say, a lot of these cases are that if you're Here under a sponsorship, domiciliary care and is a big red flag to me that the hours of work may not be in compliance with the terms of the sponsor license, terms of the certificate of sponsorship, and the arrangement that is with the sponsor. So another one where I would absolutely be saying to this person, seek some employment law advice and also thinking about immigration advice. These kind of threats are reckless. But if the employer does it, sometimes it's too late at that point and it's really difficult to claw back. But balancing that with potential employment action may change the balance, and employers can communicate with the Home Office about errors and things like that. But it's definitely one that has some worrying elements to it that would need to be unpacked more in particular settings. Needless to say, though, I would be particularly keen to understand what the terms of the contract are, what interactions there are with the certificate of sponsorship, and what it is that we can do to enforce those terms. So that brings an end to the presentation part of the event. I'm going to pause the recording now. Thank you very much for those who are watching. Our contact details are there on the website. If you have any issues or concerns that have affected you in the presentation, please do get in touch. And if we have capacity, we will be able to meet and speak with you. Alternatively, if you would like, you can see our email address and our website. There's lots of resources there that may be helpful. Thank you.